Good morning. My name is Gus Chin. I'm a municipal judge for the cities of Holiday and Cottonwood Heights in the state of Utah, and I congratulate you on joining us in this venue.
Thank you. Hello, my name is Britt Cremeyer. I'm originally from Las Vegas, Nevada. I'm a We the People alum, and I'm a practicing attorney in Boise, Idaho.
I'm an attorney in Denver, Colorado.
Please introduce yourself.
Good morning, judges. My name is Sarah Kropelnicki, and my favorite court case is Gideon v. Wainwright for the defendant's declaration that every era brings an improvement in law for the benefit of mankind.
Hello, my name is Janie Yee, and my favorite court case is Obergefell v. Hodges for its use of the 14th Amendment and its guarantee of the fundamental right to marry to same-sex couples.
Hello, judges. My name is Jaden Mason, and my favorite court case is United States v. Nixon for setting the precedent that the president is not above the law.
Hello, my name is Emma Nickel, and my favorite court case is Loving v. Virginia for upholding the Equal Protections Clause of the 14th Amendment and extending the fundamental right to marry to interracial couples. On behalf of Tahoma School District, our advisor Gretchen Wolfing, and Unit 5, we thank you for judging us today.
Thank you. I'll now read you the question for Unit 5, which reads as follows. Richard Posner wrote that, quote, "The American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets." Unquote. Do you agree or disagree with this statement? Why or why not? Additionally, to what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses? You may begin.
The right to be let alone is the most comprehensive of rights and most valued by men, Justice Louis Brandeis.
We agree with Richard Posner that the American public worries more about invasions of privacy than summary proceedings against suspected terrorists, curtailments against freedom of speech, and the media's right to publish government secrets.
A recent Reuters survey found that 3 in 4 respondents said that they would not give up their digital records to help the United States fight terrorism plots or foreign hacking.
Additionally, an astounding 79% of Americans felt that Congress should enact privacy legislation, and 65% said data privacy is one of the biggest issues our society faces.
Furthermore, we believe that Posner's argument that government investigation is more important than civilian privacy is inherently wrong, because protection of privacy outweighs the benefits of unlimited government access to private information.
In 2013, CIA employee Edward Snowden's leak of classified documents revealed the extent of civilian surveillance programs run by American and British spy agencies, placing new emphasis on the importance of civilian privacy and the dangers of unchecked government surveillance.
Therefore, unlike Posner, we believe that Americans have good reason to fear the government abusing its methods that threaten our right to privacy.
Privacy is in jeopardy today primarily due to advancements in technology that can gather data undetectably without user awareness.
Legislation has been unable to keep up with the expansion of technological feats, putting dangerous power in the hands of businesses and the government.
In 2017, entrepreneur Wonton Tat created Clearview AI, a facial recognition software that scrapes the internet to store billions of photos in a database. The company sold the software to more than 600 law enforcement agencies.
Under HIQ Labs v. LinkedIn, the Ninth Circuit Court ruled data scraping to be constitutional, since scraping data off of public websites does not expose extremely private information, such as usernames or passwords.
Most consumers are unaware of the ways in which their data is used, not only by companies with which they interact, but third parties as well.
For example, DNA testing companies that sequence consumers' genomes with a consensual sample can release that data to third parties such as the government or pharmaceutical companies.
Though the Genetic Information Non-Discrimination Act of 2008 aims to protect citizens' genetic information, healthcare providers and employers are only prevented from genetic discrimination, not releasing that data.
Though privacy is not a right explicitly stated in the Constitution, it is heavily implied through the First, Third, Fourth, Fifth, and Ninth Amendments.
In Griswold v. Connecticut, the Supreme Court used these amendments to reach the conclusion that the right of privacy is protected, as being within the protected penumbra of the specific guarantees of the Bill of Rights.
To uphold the implied rights of privacy, the Supreme Court established in Cats v. United States that if a reasonable expectation of privacy is breached, then that breach is unconstitutional under the Fourth Amendment.
This reasoning was extended to the use of mobile phones in Riley v. California, when the court declared that modern cell phones implicate privacy concerns far beyond those implicated by the search of a wallet.
This case allowed for more privacy in the digital era. As new systems such as Clearview AI are being implemented, states have offered more explicit privacy policies.
For example, the 2018 California Consumer Privacy Act protects against access to, deletion of, and sharing of personal information that is collected by businesses.
While the founding documents implied the constitutional right to privacy, the progression of technology outpaces these protections, requiring ongoing legislation.
Lovely, thank you. Since you mentioned the implied right to privacy and the use of digital medium, do we not forego some of that right by participating in that digital media?
You do have a reasonable expectation of privacy on the internet, but it heavily depends on what you are doing with that internet access. Such as if you are going on a site to advocate for taking down the national government, then of course you are not going to have a reasonable expectation of privacy to that extent.
In addition to this, if you are giving up your information online to third parties, which is implemented through Carpenter v. United States, then you have given up this information, and things on the internet cannot be taken away. It's not just, it's written in ink, and this is what third-party doctrine means in the digital era.
The third-party doctrine was founded in Cats v. United States, in which there's a wiretapping case, and the Supreme Court ruled that if you give your information to third parties, then you no longer have a reasonable expectation of privacy. However, in the digital era, we are seeing that that is no longer really existent, being that everything is going through a third party. The case that my colleague brought up, Carpenter v. United States, is an example in which we are giving our information to cell phone companies all the time. However, we still have a reasonable expectation of privacy when it comes to location tracking data. Therefore, that case ruled that you have to have a warrant. The FBI has to have a warrant if they're going to gather location tracking data from your cell phone. And this further just shows how out of touch our founding documents are, because even a case from 1950 established this third-party doctrine, which is no longer...
I'm sorry, I'm going to give my colleague Britt some time to ask a question, so sorry to cut you off.
The question I have is that you had mentioned that states are making more laws. Do you think that it's up to the states, the federal government, or do you think it's up to individuals to protect this privacy or to help find the balance between our data protection, privacy, and the common good, finding that balance of protecting the common good?
I would argue that ultimately it is up to the states whether or not to protect privacy, because the federal government sets the basis for privacy protection, like the floor to ceiling analogy. The states can go farther in privacy legislation, and we can see this through Washington State Senate Bill 6280, which creates regulation for facial recognition usage from online sectors.
I would argue that though the states do have the ultimate power in deciding the legislation for privacy, as we can see in the COVID response with certain states such as Massachusetts and Alabama taking addresses of people who test positive for COVID-19, whereas other states are not. We can see that though the states do have the ultimate power, I believe personally that the national government should have the ultimate power. Looking at acts such as the Health Insurance Accountability and Portability Act, HIPAA, we can see that that legislation protects privacy for all people's healthcare on a national level. And I feel like that is a more powerful legislation than state.
I'm going to politely disagree with my colleague Janie. I believe that the overall power belongs to the states. The federal government protects our fundamental rights through the First, Third, Fourth, Fifth, and Ninth Amendments, but privacy is not explicitly stated in the actual Constitution, but it is stated in our own Washington Constitution and in Montana, Article 2, Section 10 in their Constitution. It states that privacy is essential to the well-being of a free society, and I strongly believe that.
Les, your question, please.
To what extent does our government have a duty to investigate, by whatever means it can, the prospect of potential terrorism internally or externally? Do they have a duty to protect the American public from things like 9/11, and even if it does impact privacy?
Yes, I believe that the government does have the absolute right to use their powers in order to catch terrorists. For example, we can see with the Boston Marathon bomber that he would not have been caught if the CCTV recordings weren't released by the FBI. And I think that it's important to put away some personal privacy rights in order to protect the common good. We can see that in the case of the Boston bomber, as well as Article 1, Section 9 of the Constitution, which allows Congress to suspend habeas corpus in times of national emergency.
However, it has been seen that the federal government has gone too far when it comes to counterterrorism. For example, the CIA enhanced interrogation techniques that were used directly after 9/11 caused a huge violation for the rights of those who were suspected terrorists. Over 130 people were essentially tortured in order to get out terrorist information. However, the CIA got absolutely no information from these people, and most of them had no ties to terrorist organizations whatsoever. So this just shows how, in the name of counterterrorism, the government can be blinded by the constitutional restrictions.
And while the government can go far in these restrictions, the public actually backs these acts of enhanced interrogation techniques. A poll conducted by Suffolk University found that 57% of the public agreed with using enhanced interrogation techniques for the sake of national security, and they said that they did not care if the terrorists were armed or not.
Let me throw in the question. It was mentioned in response to the terroristic activity, the absolute right of the government to intervene. Do you think Article 1, Section 8, necessary and proper clause gives the government this absolute right? Oh, sorry, you're off the hook. Thank you. We applaud you on a job well done.
Thank you. Thank you.
Let me begin by commending you in participating in this forum, not in person in a live situation. Particularly impressed by your introduction with your favorite case. I trust that each of you are there for pursuing the legal profession as a possible arena or somehow a connection, since you had a favorite legal case. I do appreciate the arguments you raised. I do appreciate the contrast of information and the depth of information, even locally and otherwise, that you have to support your various positions. So very well done, very persuasive.
Thank you. Thank you.
I echo what Gus has said. It's so nice to see you guys. It's like you guys have coordinated your outfits even from apart remotely. I appreciated you opening with your cases. We are all kind of legal geeks, so it's always nice to get young people excited about not just our country as a whole, but specifically the nuances in the legal field. I appreciated that you were able to tie a whole bunch of different areas. This is such a big topic to cover, and you did a really good job. I took a ton of notes, but you talked about how people, 3 and 4 would not give up their privacy to help find a terrorist, but then you mentioned, how many people would come together to help find the Boston bombing terrorist. You were able to cover a lot of depth, and you had a local tie with how states, have their own constitutions to provide more protections if that's what the states want. And I always like when people genuinely disagree. I think sometimes people will disagree just to disagree, and you could tell that you guys have strong opinions as young people, and that you politely can assert those in a way that comes off perfect, even remotely, right? So congratulations to making it to state, and we're so glad to have you, and thank you for opting to do it this way. We know it's not orthodox, but you guys did a wonderful job.
Thank you.
Thank you.
I would add my appreciation to you for your hard work this semester and for the fact that you were willing to participate in this brand new form of competition. It has been very interesting to me to see how well the center in California has conducted this video competition. I am proud of them for what they have done. I'm proud of you for participating in it. with regard to your presentation, I thought it was very, very well stated. It was very well detailed. I was interested in your issue with regard to state control of information gathering as opposed to the feds. I'm not sure how effective it would be for Washington to ban the gathering of certain information if someone could go right across the border in Oregon and gather the same information. To some extent, it has to be nationwide and perhaps worldwide. But in any event, it would be a step in the right direction to have states applying pressure to other governments to try and protect citizens with regard to the gathering of this information. I thought you had a good understanding of a number of current issues, your reference to Clearview, so forth and so on. The information with regard to 79% want privacy legislation. Be aware that there is some existing legislation with regard to privacy. You might want to reference the Child Online Personal Protection Act, which prevents the gathering of information regarding those underage unless the intelligence site has the permission of their parents. And you should be aware that Google was fined $170 million for gathering that kind of underage information and selling it to businesses and the like. The reference to the California legislation I thought was very, very interesting. The reference to scraping was very, very interesting. But quite clearly, the citizens must act. And that's why I'm proud of you for being involved in this program. You have more understanding of this issue than almost 98% of the older adults, shall we say. And it is your duty to stay informed with regard to this information, with regard to our privacy, with regard to what we can do to try and protect ourselves. Be politically active. I ask that of you as graduates of this program, and I am a great fan of this program. I've been involved with it for 26 years. And I can only tell you, I'm so proud of the students who have gone through it and what they have managed to do. One of your judges is a graduate of this program, which tells you how extensive this program is. Again, thank you for your efforts.
Thank you.